At exactly 10:38 a.m. Eastern Time this morning, the presiding federal judge in the Southern District of New York interrupted a scheduled pretrial conference and did something that three veteran court reporters who were present say they have never witnessed in a federal proceeding of this magnitude. She ordered the courtroom doors locked. She instructed the U.S. Marshals to ensure no one entered or exited. She turned directly to the defense table, and then she issued a warning that lasted 7 minutes and 43 seconds without stopping once. During those 7 minutes and 43 seconds, she used the word obstruction 4 times. She used the phrase willful noncompliance 3 times. She cited 2 specific federal criminal statutes by number from memory without looking at any notes. And she gave the defense team a deadline that no one in that courtroom expected. 48 hours, 2 days. Not to file a motion, not to submit a brief, but to physically produce documents that prosecutors say should have been surrendered to them 9 weeks ago. Documents that the judge now believes were deliberately withheld from the court. If those documents are not produced by Thursday at noon Eastern Time, the judge stated on the record that she will impose the most severe sanctions available under federal law, including a potential adverse inference instruction to the jury, a contempt finding against the lead defense attorney personally, and a formal referral to the Department of Justice Inspector General for a criminal obstruction investigation. The defense team did not see this coming. According to 2 attorneys who were inside the courtroom when the doors were locked, the lead defense attorney stood up twice to object during the warning and was told both times to sit down. His co-counsel was visibly writing notes at a speed that suggested she was trying to capture every word for an immediate appeal. And within 1 hour of the courtroom doors being unlocked, the defense filed an emergency motion asking the judge to recuse herself from the case. That recusal motion was denied at 12:14 p.m. today, 96 minutes after it was filed. The denial was 1 paragraph long. The judge wrote that enforcing discovery compliance is a core judicial function, and that a party's objection to enforcement does not constitute grounds for disqualification. She ended the denial with a single sentence that legal analysts are calling the most significant judicial statement of the year. The court's patience has been exhausted, and its tolerance for procedural obstruction has reached its limit. This is NextGen Politics. Every detail in this video comes from court transcripts, docket entries, procedural orders, and established federal case law. What happened this morning fundamentally changes this case. Stay with me because the details matter and the consequences are enormous. Here is what triggered the judge's warning and why the defense team had no answer for it. 9 weeks ago, the prosecution filed a routine discovery request under Federal Rule of Criminal Procedure 16. They asked the defense to produce all electronic communications between the defendant and a group of 6 individuals. These 6 individuals are financial advisors, property managers, and bank loan officers who are named in the indictment as participants in the alleged fraud scheme. The request covered a 5-year period from 2015 to 2020. It was specific, it was narrow, and it was entirely standard for a case of this nature. The defense did not object to the request. They did not claim the materials were privileged. They did not argue the scope was too broad. They acknowledged the request and said they would comply. And then for 9 weeks they produced almost nothing. 3 weeks after the request was made, the prosecution filed a follow-up asking about the status of the production. The defense responded with a letter saying the document gathering process was ongoing. 5 weeks after the request, the prosecution filed a motion to compel production. The judge granted that motion and ordered the defense to comply within 10 days. The defense produced 200 pages of documents covering only 2 of the 6 named individuals. Nothing was produced for the other 4. The prosecution filed a second motion to compel 3 weeks ago. This time, the motion included something new, something that changed everything. It included a sworn declaration from the technology company that manages the defendant's email systems. Before we go further, here is the sourcing for everything discussed in this video. The judge's warning is preserved in the official court transcript filed as an exhibit to this morning's procedural order. The prosecution's motions are public docket entries available through the federal court electronic filing system. The technology company's sworn declaration is attached as an exhibit to the prosecution's second motion to compel. And the legal analysis is based on federal rules of criminal procedure, federal evidence rules, and Supreme Court precedent that any attorney can verify. These are institutional court records. Nothing in this video relies on unnamed sources or unverified claims. Now here is what that technology company's sworn declaration revealed and why it caused the judge to lock the courtroom doors this morning. 6 months ago, prosecutors subpoenaed the technology company for server logs covering the defendant's email accounts. Server logs do not contain the content of emails. They contain metadata: who sent the email, who received it, when it was sent, the subject line, the file size, whether attachments were included. Think of server logs as a phone bill. The bill does not tell you what was said during the call, but it tells you every call that was made and how long each one lasted. The technology company produced logs covering approximately 38,000 emails sent or received by the defendant's accounts during the 5-year period. Prosecutors already had copies of many of these emails obtained through separate subpoenas to banks and financial institutions. But when they cross-referenced the server logs against the documents in their possession, they found a gap. There were 417 emails in the server logs that corresponded to communications with the 6 named individuals. Of those 417, prosecutors already had copies of 261 obtained from the banks and institutions on the other end of those communications. That left 156 emails that prosecutors knew existed based on the server metadata, but did not have copies of because they were stored only on the defendant's systems. Those 156 emails are exactly what the prosecution requested 9 weeks ago. And those are the emails the defense has not produced. But the devastating part is not the failure to produce them. The devastating part is what happened to them. The technology company maintains backup servers that automatically copy all emails for disaster recovery. These backups are retained for a minimum of 7 years. Prosecutors subpoenaed the backup server data and compared it to the primary server data. The comparison revealed that 119 of the 156 missing emails had been present on the primary server as recently as 8 months ago. But sometime between 8 months ago and 5 months ago, those 119 emails were removed from the primary server. Deleted. Gone. And here is the detail that made the judge lock those doors. The technology company confirmed in its sworn declaration that a litigation hold was placed on all of the defendant's email accounts 15 months ago. A litigation hold is a formal legal instruction that prohibits the deletion of any documents that might be relevant to pending or anticipated litigation. Once a litigation hold is in place, nothing gets deleted, not manually, not automatically, nothing. But 119 emails were deleted anyway, after the litigation hold, after the investigation became public, and before the prosecution formally requested those specific documents. The judge read the technology company's declaration before this morning's hearing. She came into that courtroom already knowing what the prosecution was going to present. And when the lead prosecutor stood up and began walking through the timeline, the judge did not wait for the presentation to finish. She stopped it at the point where the deletion timeline was described. She locked the doors, and she turned to the defense table. Now here is why those 119 deleted emails matter so much that a federal judge considered them worth locking a courtroom over. Prosecutors cannot recover the full content of the deleted emails from the primary server, but they have been able to partially reconstruct many of them using a technique called reply chain analysis. When someone sends an email and the recipient replies, the original message is typically embedded at the bottom of the reply. If the defendant sent an email that was later deleted from his server, but the recipient's reply still exists on the bank's server, prosecutors can read the original message because it is quoted inside the reply. Through this technique, prosecutors have reconstructed partial content from 74 of the 119 deleted emails. And what those reconstructed emails contain is devastating to the defense. The first category involves direct instructions about property valuations. In 22 of the reconstructed emails, the defendant provides specific dollar values for properties and directs the recipient to use those values in loan applications or financial statements. In 13 of those 22 emails, The values specified by the defendant exceed independent professional appraisals for those same properties by margins ranging from 25% to 58%. A 25% overvaluation might be explained as an aggressive but defensible estimate. A 58% overvaluation cannot be explained by any legitimate methodology. That is not a difference of opinion among professionals. That is deliberate inflation of asset values to obtain larger loans. The second category involves discussions about tax reporting. In 16 of the reconstructed emails, there are references to property values being reported to tax authorities. In 9 of those 16, the values discussed for tax purposes are significantly lower than the values used for the same properties in loan applications during the same year. In 3 of those 9 emails, the defendant uses language that prosecutors describe in their filing as explicit acknowledgement of dual valuations. The filing does not quote the exact language from the emails, but it states that the defendant references different numbers for different purposes in a manner that demonstrates awareness that the values being used were not consistent across financial documents. Different numbers for the same property, higher numbers for banks to get bigger loans, lower numbers for the IRS to pay less tax, and the defendant's own emails discussing both sets of numbers. The third category is communications about the discovery process itself, and this is the category that triggered the judge's most severe language. In 6 of the reconstructed emails dated after the investigation became public, there are discussions about document preservation. These emails are not between the defendant and the 6 named financial individuals. They are between the defendant and members of his own staff discussing which documents to keep and which ones were, in the words used in the filing, no longer necessary. If those emails say what prosecutors believe they say, they are not just evidence of fraud. They are evidence of obstruction. Discussing which documents to eliminate after a litigation hold is in place and after a federal investigation has been announced is consciousness of guilt. It shows awareness that the documents were damaging and a deliberate decision to destroy them. The defense filed 3 emergency motions within 2 hours of the judge's warning. All 3 were denied by the end of the business day. Here is what they argued and why every argument failed. The first motion requested recusal of the judge on the grounds that her warning demonstrated prejudgment and bias against the defendant. The defense cited her use of the word obstruction as evidence that she had already concluded the defendant was guilty of obstructing justice before any hearing on the merits. The judge denied this motion citing Lidicke v. United States from 1994. In that case, the Supreme Court ruled that opinions formed by a judge based on facts introduced during the proceedings do not constitute bias unless they reveal a deep-seated antagonism that makes fair judgment impossible. Enforcing discovery rules and warning attorneys about the consequences of noncompliance is not bias. It is standard judicial practice. Every federal judge in the country does it. If issuing warnings constituted grounds for recusal, no judge could ever enforce any rule. The second motion requested an emergency stay of the 48-hour deadline pending an appeal to the Second Circuit. To obtain a stay, the defense needed to show a likelihood of success on appeal and irreparable harm if the stay were not granted. The judge denied the stay on both grounds. On likelihood of success, she noted that discovery enforcement orders are reviewed under an abuse of discretion standard, meaning the appellate court would only reverse if her order was clearly unreasonable. Ordering the production of documents that should have been produced 9 weeks ago is not unreasonable. It is the minimum expectation of the court. On irreparable harm, she noted that producing documents a party is legally obligated to produce does not constitute harm. It constitutes compliance. The third motion was the most aggressive. The defense argued that the backup server data should be excluded from consideration because the subpoena that obtained it exceeded the original scope of the investigation. This is an attempt to invoke the fruit of the poisonous tree doctrine, which excludes evidence obtained through unlawful means. The judge rejected this entirely. The subpoena was issued under lawful grand jury authority. The technology company complied voluntarily. No constitutional rights were violated. The fruit of the poisonous tree doctrine applies when evidence is obtained illegally, not when a party dislikes the evidence that lawful process uncovered. The judge wrote that the defense's attempt to recharacterize a lawful subpoena as overreaching is without factual or legal basis, and the motion is denied. 3 motions, 3 denials. The fastest denial took 96 minutes. The slowest took 4 hours. All 3 were rejected on well-established legal grounds that the defense team should have known would not succeed. Filing motions you know will fail is not legal strategy. It is delay tactics dressed in procedural clothing, and this judge has made clear she will not tolerate it. This morning's confrontation changes this case in 3 ways that cannot be reversed regardless of what happens in the next 48 hours. First, the judge has put obstruction of justice formally on the record as a potential issue. By citing specific federal statutes from the bench, she created an official transcript that prosecutors can use as a foundation for pursuing additional charges. Even if the defendant is acquitted of every fraud count, the email deletions could support separate obstruction charges under 18 U.S.C. Section 1519, which makes it a felony to destroy documents with the intent to impede a federal investigation. The litigation hold, the server logs, and the deletion timeline may be sufficient to establish every element of that offense. Second, the defense has lost one of its most important trial strategies. Before today, defense attorneys could have argued at trial that the prosecution's evidence was incomplete and that missing documents might have contained information favorable to the defendant. That argument is now destroyed. The judge has established on the record that the documents are missing because the defense failed to produce them and may have destroyed them. If the defense tries to point to gaps in the evidence at trial, the prosecution will respond with the judge's own words, showing those gaps were created by the defense. Third, the judge has established the tone for the remainder of this case. Defense attorneys in high-profile cases test judges early to see how far they can push. This judge has now answered that question definitively. She locked the courtroom. She issued a 7-minute warning without interruption. She denied 3 emergency motions in a single day. She set a 48-hour deadline with consequences, including criminal referral. The message is clear. This court will not be manipulated. This case will not be delayed, and the rules apply to everyone equally. The 48-hour deadline expires Thursday at noon Eastern Time. Between now and then, 4 developments will reveal everything about where this case is heading. The first is whether the defense produces the documents. Full production means the emails were withheld but not destroyed. Partial production means some were deleted, and the defense is minimizing damage. No production means the defense has decided the sanctions are less damaging than whatever the emails contain. Each scenario triggers a different judicial response, and each one tells you how serious the underlying evidence is. The second is whether the prosecution files for additional charges. If prosecutors present the deletion evidence to the grand jury within the next 2 weeks, obstruction charges are coming. Watch for increased grand jury activity on Tuesdays and Thursdays. More witnesses plus more sessions equals more counts. The third is whether the defense team changes. The judge questioned the lead attorney's professional conduct directly. If he faces personal sanctions or potential disciplinary proceedings, he may withdraw from the case. A change in lead counsel this close to trial would delay everything. The fourth is whether additional cooperating witnesses emerge. When institutional pressure increases and judicial warnings become public, people inside the defendant's circle start calculating their own legal exposure. If a second insider comes forward within the next 30 days, this case transforms from a prosecution into an avalanche. What happened at 10:38 this morning was not a routine hearing. A federal judge locked a courtroom, cited criminal statutes from memory, and told the defense team that their conduct was approaching the line between aggressive advocacy and criminal obstruction. She gave them 48 hours to step back from that line. The Southern District of New York is the court that prosecuted the Mafia Commission in 1986. It is the court that handled the Madoff case. It is the court that has consistently demonstrated that no defendant is above the rules of the federal justice system regardless of their wealth, their power, or their political connections. This judge is operating within that tradition. The warning has been given. The clock is running. 48 hours. And what happens when that clock reaches 0 will reshape this case entirely. This is NextGen Politics. Subscribe right now and turn on all notifications because we will be covering every filing and every motion between now and Thursday's deadline. When the 48 hours expire, You will want to be here to understand exactly what it means and what comes next. The courtroom doors were locked this morning, but the transcript is public. The docket entries are filed, and the judge's words are now permanent record. Do not miss what happens next.